This floor is back in session. You may be seated.
Recording in progress.
Let me make one announcement, that is for any of you who would prefer to be in a less crowded situation. We are live streaming, if I understand correctly, live streaming these proceedings in the jury assembly room on the first floor, and you'll be able to see and hear everything that takes place in this courtroom. Now, gentlemen, we are at the stage where I'd like to address the issue of the final charge of the court and the jury's verdict form that we have prepared in draft form. Is there any issues that you want to address before we take it further?
Yes, Your Honor.
First off, Your Honor, the state and the defense have agreed that in counts 4 and 5, don't have a page number, but under, I guess it'd be the subsection 1, the defendant knowingly obtained or exercised
It's on
control.
page 11.
Okay. The word under B, instead of owned by Sergeant Daniel Scott Baker, change that to possessed by.
Right. So in count 5, alleged to be Sergeant Daniel Baker's service weapon, is that what you're talking about? That's going to be changed, the count is going to be changed to possessed by Sergeant Daniel Baker,
Correct.
and that's the Glock 17.
As well as the 33.
So we need to change the language of the jury charge in count 5
Correct.
only to say, in count 5 alleged to be possessed by Sergeant Daniel Baker. Well, it should be alleged to be, count 5, it should be just, it's not going to make much sense to read it like that. Let's change it to say this, in count 5, a Glock 17 handgun alleged to be possessed by Sergeant Daniel Baker. Does that make more sense the way that's worded in count? So we would now read, in count 5, a Glock 17 handgun alleged to be possessed by Sergeant Daniel Baker, and a Glock 33 handgun and ammunition. Now this says owned by Sergeant Baker. That was the gift that I believe Mrs. Baker. Is there any reason to change that language?
If you change it the way you're proposing, then no.
All right. So with changing the first part of that subsection, that would effectively, would both sides agree, that would effectively solve that problem?
Yes, Your Honor.
All right. What other? All right, let me read it to you again. Count 5 would now be, and the language of the charge would be that the defendant knowingly obtained or exercised control over property. And in count A remains the same. Count B would now read, in count 5, a Glock 17 handgun alleged to be possessed by Sergeant Daniel Baker, and Sergeant Baker's backup weapon, a Glock 33 handgun and ammunition owned by Sergeant Daniel Baker.
So no reference to a baby's service weapon? No reference to a baby's service weapon?
So it would be, do you want it referred to his service weapon, a Glock 17 handgun, his alleged to be possessed by Sergeant Baker as his service weapon? Let's do it that way.
Yes, please.
All right, so let's repeat it one more time just to make sure we're all safe, on the same page. In count 5, comma, a Glock 17 handgun alleged to be possessed by Sergeant Baker as his service weapon. And that would be the only change to that. And then the backup weapon would be remaining, the language would be the same. All right, Mr. White?
Then, Your Honor, at the bottom of page, I believe it's 33, there's an instruction dealing with the state must prove beyond a reasonable doubt the culpable mental state of the accused. The state's concern, Your Honor, is that in count one, the court lays out the jury instruction and the definition for knowingly and intentionally, which is referred back to through the remainder of the 10 counts. The concern is by putting way toward the end of the instruction this additional instruction regarding culpable mental state, it may lead the jury to believe that we had to put on proof, like some sort of mental health proof, as opposed to what's already defined.
Move it to coordinate with the language. The language about the culpable mental state is worded differently under the premeditation instruction. It was a request specifically by the defendant, and it does accurately state the law.
Correct.
So my thought would be if we just moved that from the position toward the end of the instructions, and I understand the state's position regarding that giving it some sort of extra influence by placing it toward the end of the instructions, that may indicate that there is some additional proof needed. But if it's a correct statement of the law, and if we place that in conjunction with the other language of the premeditation, then it would seem to me to be maybe slightly repetitious, maybe something that's being stated in simply a different form, but it is a correct statement of the law. So my thought would be we simply move that paragraph and insert it in the Ms. Jones, any reason we could not insert it after the definition of premeditation, where it gives a premeditated act as one done after the exercise, and we can put it at the on page 7 of the instructions, at the conclusion of that preceding paragraph, state language there. Well, we can put it, can we not put it as to both of those two counts that require the premeditation? I'm not sure I'm following.
It's just a general charge about the manslaughter offense, and the entire charge, as this paragraph is affected by its you testified about manslaughter. And so he was simply asking. If we put it inside of a single count, it would only apply to that count.
Understand. Well, why don't we do it this way then? Let's move that to the beginning of the charge, where we're giving general instructions regarding proof beyond a reasonable doubt. Why don't we put it on page 3? The concern being that Ms. Jones has brought correctly to my attention is that adding it where I was suggesting moving it would seem to indicate that it only applies to that one count rather than the law in general, all of it counts. So my thought would be to solve the problem with moving it from the end where it seems to be given extra emphasis, that we could put it on page 3, but after the language, the paragraph that says the state has the burden of proving the guilt of the defendant beyond a reasonable doubt, then it would be logically could be inserted right behind that paragraph as a general instruction, and it would apply then to all of the charges that would be necessary. Would it not solve the problem that the state's objection to, but also include the language?
I don't have any objection to be it.
Ms. Jones, any objection for you to do it that way?
So after reasonable doubt, is that what you're saying?
Yeah, I'm talking about, let me show you. This has, the state has the burden of proof beyond a reasonable doubt. Not required to prove his innocence. The statement is proved beyond all the elements of the crime. So that's where I'm talking about inserting it right here. So this would be inserted right after the paragraph that says the state must have proven beyond a reasonable doubt all of the elements of the crime charged and that it was committed before the finding or returning of the indictment in this case. Then it goes on to say the state must prove beyond a reasonable doubt the culpable mental state of the accused, and that would be logically seeming to me that makes sense that it's continuing, and that it includes the language requested by the defense without placing it at the end where it seems to give it greater emphasis. All right? And anything else regarding the charge? And are you satisfied if we make that one change, and are both sides satisfied with the language?
Yes, Your Honor. Yes.
For the record, let the record reflect that everyone except Ms. Jones has accepted the charge.
It's not the charges,
All right, so we, for the record, both sides have now agreed with that minor change, that we are going to, go ahead and finalize this charge of the court with that, moving that one paragraph earlier into the charge, and then we will move to the verdict form. The verdict forms, as to count one, is there any objection to that language and the way it's phrased?
No.
Count two, first premeditated first-degree murder, any objection to the verdict form in that phrase?
No, Your Honor.
Count three, premeditated, or rather a felony murder charge, any objection to the language?
No, Your Honor.
Count four, any objection to that language?
No, Your Honor.
Count five is the one that we'll need to change because it states verdict form count five, theft of property owned by Sergeant Daniel Baker. It needs to say owned by Sergeant Daniel Baker or possessed or assigned to and possessed by Sergeant Baker. Can we change that language? Because the state's position is that it included both a weapon owned by him personally as well as his service weapon. So theft of property owned by Sergeant Daniel Baker and signed and yes, we'll make it owned by Sergeant Baker and possessed by Sergeant Baker. All right. You,
Or possessed.
well, which do you have? Let's see.
I have or because it's two different articles.
Okay. All right. The language will be count five, theft of property owned by Sergeant Daniel Baker or possessed by Sergeant Baker. All right, with that change, is there any other change in the verdict form for count five?
No, Your Honor.
Any objection to count six language? Count seven? Count eight? Or count nine? Or count 10? Anybody have any objection to the language of the verdict form?
No, Your Honor.
All right, then we will make those changes to both the charge and to the verdict forms and have those ready and printed before the jury retires to deliberate. All right, then we're ready to bring the jury in so that we can deal with the state's closure of their proof, is that correct?
Yes, sir.
All right, let's bring the jury in. This is where we're going to change. We're going to insert that culpable mental state like that. And then the verdict form, have you got that or it's just?
I just want to make sure I have the language correct.
Copy of
Good morning, ladies and gentlemen. Hope you had a restful night and you're ready. We've given you a little extra time this morning, so hopefully we can get started now. All right, at this point, the state may call your next witness.
Your Honor, the state rests.
All right. Ladies and gentlemen, the state has rested their proof. And while I just had you walk in here for that, I'm going to have you walk back out across the hallway. When I do this thing, it's not just to irritate you, it's actually for a legitimate legal purpose, so that I understand there are procedures that I have to follow. So that was something that we needed to do this morning rather than last night, just on the outside chance something might happen. So we have now rested the state's proof, and if you will cross the hallway and let us bring you back in just a few moments, then we'll continue with it. All right. Anything the state has rested their proof. Mr. Evans?
Yes, Your Honor, I do have a motion to the court. Your Honor, pursuant to Rule 29 of the Rules of Criminal Procedure, we would move for a motion for judgment of acquittal as to count 3 of the indictment, felony murder. Your Honor, the state's proposition and proof, and even viewed in a light most favorable to the state, giving them every reasonable inference, they have failed to put on sufficient evidence of a murder and perpetration of the theft. Your Honor, the proof as it's been laid out is that there was Sergeant Baker approached the vehicle on Temple Switch. The shooting occurred, and then the vehicle was taken. Your Honor, this presents a situation where the killing was not causally related to the theft of the vehicle pursuant to Tennessee law. There's several cases that bear out this logic, specifically one being State versus Terry. It says, in determining whether the evidence was sufficient to support a conviction of murder and the perpetration of larceny, courts had to consider whether the killing was temporally, spatially, and causally connected to the initial taking of the property. Your Honor, what that envisions is that the felony murder rule, as we all know, is the initiating crime, the intent to commit the underlying crime is what carries the action. It's what carries the action, is what leads to, that is the intent that leads to the killing itself during the perpetration of that felony. That's not the proof here. If you look at State versus Sweat as well, it talks about the felony murder rule is a legal fiction in which the intent and the malice to commit the underlying felony is transferred to elevate an unintentional killing to first-degree murder. Your Honor, every inference in this case is that the proof of this case is that it was not an unintentional murder. The intent of the interaction was the killing, and that the taking of the vehicle was an after effect or afterthought, Your Honor. So for those reasons, we would ask the court to grant a judgment of acquittal in this case as to this count, based on the facts presented and the laws that's before us in the state of Tennessee. No rational trier of fact could find the elements beyond a reasonable doubt as to felony murder. Thank you.
Anything from the state?
Yes, Your Honor.
Your Honor, in reviewing a motion for judgment of acquittal, the trial judge is only concerned with the legal sufficiency of the evidence and not the weight of the evidence. And Judge, this empowers the trial court to make this ruling only when evidence is insufficient to warrant a conviction, either at the time the state rests or at the conclusion of all evidence. And I'm quoting from State versus Collier, 411 Southwest 3rd, 886. And as Mr. Evans alluded to, the trial court must favor the opponent of the motion, in this case the state, with the legitimate view of the evidence, including all reasonable inferences, and discard any countervailing evidence. In this case, as it pertains to count 3 of the felony murders count, the murder and the premeditated murder or in the perpetration of a felony, Based on the facts of this case, Mr. Wiggins, in his interview with Agent Neese, as well as his statements to Mr. Hudnall, one way or another, he was not going to go to jail. He has 2 active warrants. He discusses the fact that he was moving out of state to flee. In that situation, he's at the corner of Tidwell Switch and San Vineyard Roads here in Dixon County with a vehicle that's inoperable. So how does one who has every intent to flee from police when there's only one operating vehicle at the scene, which is, in this case, the car 500, how is he going to flee? He's going to steal that car. And so how is he going to steal that car? The only way he did it in this case was to murder Sergeant Daniel Baker. The jury instruction for felony murder states that the intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. With that in mind, as I stated earlier, we're looking at a sufficiency of the evidence analysis. And in this case, there is ample evidence for the trier of fact, in this case the jury, to look at the facts and circumstances of what they've heard at this trial and come to the conclusion that Mr. Wiggins' intent to commit the underlying felony, the theft, existed prior to or concurrent with the commission of the act causing the death. And for that reason, Your Honor, the state moves or asks that you deny the defense motion for judgment of acquittal as to count 3.
All right. As was correctly pointed out, the court must view the evidence in this situation, and the court finds that there is sufficient evidence to indicate in the record that, based upon the statements of the defendant to law enforcement following the shooting, that he had intended to flee the area because of warrants and was planning to leave. There's also evidence in the record that he indicated he would resist being taken into custody if someone tried to pull him over, that he would in fact smoke them, or whatever the language was that he actually used. He was found in a vehicle that was disabled with a flat tire, and more importantly, that the evidence established that immediately shooting Sergeant Baker for no other reason, he took possession. Even he could not give another reason as to the shooting took place other than allegedly being frightened. But immediately following the shooting, he took possession of the Unit 500, and after loading Sergeant Baker's body in it, he used that vehicle to flee the scene. That, plus the statements that he had made to law enforcement following the shooting, plus the statement of witness Hudnall, it is this court's opinion that there is sufficient evidence that a reasonable jury could conclude that the murder of Sergeant Baker was committed in an effort to obtain the vehicle as a means of fleeing the scene, and therefore the court finds that the motion for judgment of acquittal should be respectfully denied. Then we are ready for the next step in this process. Does the defense have any witnesses they wish to call?
No, Your Honor.
We need to then conduct Mr. Wiggins will need to come to the witness stand and be placed under oath.
And raise your right hand.
I'm sorry. Raise your right hand, please.
Do you solemnly swear affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Right. And if you will take the witness stand, Mr. Wiggins. If you will, offer help. Thank you.
Mr. Wiggins, have I, along with Mr. Simmons and Mr. Hopkins, fully explained to you your right, absolute right, to testify on your own behalf in this trial?
Yes, sir.
Likewise, have the three of us also fully explained to you your right not to have to testify, to ever have to testify in this trial?
Yes, sir.
And do you understand those rights?
Yes, sir.
And understanding those rights and having talked about that, is it your desire today not to testify on your own behalf?
Yes, sir.
Thank you, Your
All
Honor.
right, Mr. Wiggins, my job is to make sure that you are making a knowing and voluntary waiver of your right to testify. Do you understand that if you want to testify on your own behalf at this trial, that you have that absolute right and no one can stop you from doing so?
Yes, sir.
But likewise, do you understand that if you choose not to testify, no one can make you testify? Do you understand that?
Yes, sir.
And do you understand that if you choose not to testify, that the court will instruct the jury that they are to have no inference that arises from your refusal or declining to testify at your own trial?
Yes, sir.
Is this a decision that you've discussed with your lawyers?
Yes, sir.
And is this a voluntary and intelligent and knowing decision on your part?
Yes, sir.
All right. Now, I found that he has knowingly and intelligently waived his right to testify in the case. So,
Thank you, Your Honor.
then he may step back to That's fine. Mr. Evans, just for the record, since there is some issue that's been raised in both pretrial issues, is there any basis upon which that the defense would have any reason to think that Mr. Wiggins does not fully understand or comprehend his waiver of his rights?
No, Your Honor.
All right, let's record reflect there is no basis. Then the next step would be for us to return the jury to the courtroom and allow the defense to state that they rest their proof. And then we will move to closing arguments. Is both sides ready to begin with the closing arguments?
Yes, Your Honor.
And Your Honor, can we ask for the podium to be?
All right. Do you want to do it, or do you want these guys to do it? Only weighs about 300 pounds, so. Now that will leave it correct that. We can make sure that's it. All right, then with that modification of our room, are we ready for the jury to return? And we'll bring in the jury. Once the defense rests their proof, then I intend to move directly into closing argument. All right, thank you, ladies and gentlemen. The state has rested their proofs. Does the defense wish to offer any proof?
Your Honor, the defense rests.
Defense has rested. That means that you have now heard all of the evidence and proof that you will hear to help you decide this case on this phase of the trial. The next step will be the closing arguments of the attorneys, and the state will have the opportunity to open and close after the defense. Ms. General Sagi. Hold on just a second, General. begin that, let me just state for the record, for the satisfaction of the jury. Ladies and gentlemen, if you remember that when we were in this trial, that there was some evidence that was given in a video about a Social Security number that was not the Social Security number. If you remember, we omitted that to protect it's an acronym, Social Security. To their credit, both sides have agreed and stipulated that would be not presented to you, that number would not be presented, but they stipulate that it was not a correct number. And that stipulation has been reduced to writing and has now been made a part of the record, so that you're clear. All right, now, General Sagi, you may proceed.
Thank you, Judge. On May the 30th, 2018, Stephen Wiggins, the defendant, took the life of Dixon County Sheriff's Deputy Sergeant Daniel Baker when he murdered him by methodically shooting Sergeant Daniel Baker 6 times. I want to begin by first thanking you all for your service. It's been a long journey. It's been a lot of days. With this dedication and participation in the criminal justice system, and your civic duty is very important. Now is the time that we get to argue our case, to put it all together for you all, to show you what we believe the proof aligns with the law to get to a verdict. And I'm going to take this time to walk through what we learned, what you all observed, and how this actually applies to the law and the decisions that you all are going to have to make. The defendant in this charge in this indictment has been charged with 10 counts. I think the best way to address all of this is to rewind, to revisit the information as it happened. We're here today because on May the 30th, 2018, when Sergeant Daniel Baker got up, got dressed, got ready for work, checked on shift, he responded to a call, a welfare check, a citizen calling in, trying to look out for another human being. Sergeant Baker, attempting to assist other officers to take the burden off of them, responded out to the intersection of Tidwell Switch and Sam Vineyard Road. When Sergeant Baker got there in his Patrol Unit 500, you saw the video. He parked, he got out of his vehicle, he approaches a Saturn parked in the wrong lane of the road, a hazard for other individuals, and perhaps a vehicle in distress needing assistance itself. And he walks up and he looks in the vehicle and he sees 2 people. And you could see this. You saw the body cam footage of what the interactions actually were. Sergeant Baker, arguably believing that this is a motorist assist, the car obviously had a flat tire. It was immobile. It couldn't go anywhere. This appears as a citizen who needs help. But what does Sergeant Baker actually encounter? Sergeant Baker encounters the defendant, Stephen Wiggins. And if you recall from day 1 of testimony, if we rewind just one day earlier, what was Stephen Wiggins doing in Kingston Springs, Tennessee, in Cheatham County? You heard testimony that he was at a motel. You heard testimony that there was something that happened, and he fled. He left. Ms. Bonsignor sat here and told you about a phone call she received from a male she found out was Mr. Wiggins. And he was checking on this female as her brother. And he wanted to know if the cops were still there. Ms. Bonsignor let him know that they weren't. And you know who came back? Mr. Wiggins, after the police had left. And Mr. Wiggins collected Eric Castro Miles and got into the vehicle that she has just reported stolen and drove off. At that point, he made it clear he didn't want police contact. He also made statements, according to Mr. Brian Hudnall, a month earlier, that if he came into contact with law enforcement, he would, and they tried to arrest him, he would, quote, smoke their ass. So Sergeant Baker walks up to Stephen Wiggins, an individual who already has a motive. He has a motive that he doesn't want police contact, and he has a reason for that. So when Sergeant Baker walks up and asks him for his name and his identification, you all watch this. Did he give the correct name and identification? No. And we'd submit to you that's because he didn't want to be detected. He didn't want the police to find out who he was. So Mr. Wiggins sits there and he starts to appear a little upset, trying to arguably distract the officer. The officer does a routine thing, gets the name of the passenger, tries to get identification, calls in the tag number for the vehicle. And where they were, it's bad radio reception, it's bad cell phone service. He gets the confirmation that the vehicle is stolen, and his alert level goes up. And he walks back over to the driver's side door and wants the defendant out of the car. And the defendant already knows that he has to arguably leave. There's one operable vehicle there, the police cruiser. So when Sergeant Baker walks up to the car window and draws his weapon, and he does, you all saw that on there, and orders the defendant out of the car, he tries to tell him the door doesn't work, and he needs his pliers, because he can't get out of the car. And ladies and gentlemen, you saw the video the day before of the car door opening with the defendant getting it out of it. And in this situation, Sergeant Baker, he tries to de-escalate it. He tries to calm this individual down so he can investigate, so he can figure out what is going on. And in the meantime, while he de-escalates, he reholsters that weapon, and you can hear that click. And in an effort to assist the defendant in the situation, he reholsters that weapon and he walks around the car. And what happens next? Sergeant Baker is ambushed by Stephen Wiggins. Stephen Wiggins made the decision to pull that handgun, that high point, out from under that seat or wherever else it was in that car. And as Sergeant Baker approached the passenger side, without warning, without provocation, he fires his weapon out of the window, striking Sergeant Baker numerous times. And you heard that, and you saw that. And you saw Daniel Baker trying to get away from the defendant, trying to warn other officers. Shots fired, officer down. And then you saw him fall to the ground. And you heard him. And you heard more shots. And you heard his breathing. And you heard the moaning. And then you heard more shots as the defendant arguably was in closer proximity. And then you saw the defendant's head over the body of Daniel Baker on his body camera. And then immediately, the defendant takes arguably the keys that are in his pocket, runs up to the police cruiser, drives the police cruiser down, and starts loading Daniel Baker into the back because the defendant knows he has to get away. Now, ladies and gentlemen, you're going to be asking this to determine whether or not the defendant, Stephen Wiggins, committed first-degree murder, premeditated first-degree murder. I want to talk to you about that. First-degree murder is when the defendant unlawfully kills the alleged victim. Now, these are jury instructions that you all are going to have with you that you can consider back in the jury room. The defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, and the killing was premeditated. Ladies and gentlemen, I submit there is no question here that the defendant unlawfully killed Sergeant Baker. There was no lawful means for him to kill a law enforcement officer in this situation. None. He acted intentionally. And how do we know he acts intentionally? He doesn't just shoot one time. He shoots 3 different groupings. And this killing is premeditated. A premeditated act is one that is done after the exercise of reflection and judgment. The premeditation means that the intent to kill must have been formed prior to the killing, the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. But in this case, ladies and gentlemen, we have some interesting pieces of information. We know that the defendant is already trying to elude law enforcement. We know from Mr. Hudnall that he has already made statements about what he will do to law enforcement if, in fact, he encounters them. He will smoke their ass. And we know from his own statement that he said he was leaving. He had to get out of there. And he knew that he had to get rid of a body, get rid of evidence, and get rid of other things. And ladies and gentlemen, let's think about this situation tactically. Mr. Wiggins tried several tactics to get out of this. He's lied to the police officer about who he is. He's arguably not being truthful about the door handle able to be opened. And we know that specifically, too, in this moment, because after the first shots are fired through the window, through the passenger side window, he doesn't take minutes to find pliers to open that door. He is out. And he is, in that time, hunting down Sergeant Baker. It was a ruse to buy time for his plan. He waits until Sergeant Baker tries to de-escalate, has reholstered his weapon, and is in a vulnerable position before he strikes. He's also farther away from Sergeant Baker. Sergeant Baker couldn't reach the defendant. There's a person between them. He waited. He knew what he was doing. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion to be capable of premeditation. Ladies and gentlemen, I think that's clear here. You can observe how he behaved immediately after the three groupings of shots fired. Daniel Baker. He's not having a breakdown. Because he doesn't want to be caught. So he loads the officer head first into the back seat of the vehicle, and he takes off. And then, you know, what you don't hear on that, when you see Mr. Wiggins' face on that video camera, submit to you, does he look distressed? Does he look upset? Does he look like he's panicking? If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. In other words, he thought about it. If he was a little excitable then, but he still carried it out, we still have first-degree premeditated murder. And furthermore, premeditation can be found if the decision to kill is first formed during any heat of passion, but the accused commits the act after the passion has subsided. And in this case, we'd submit to you that we don't have that. We have an officer who's de-escalated a situation, who has reholstered a weapon. There's no gun in his face. So after Mr. Wiggins begins to load Sergeant Baker into Unit 500, he takes off with him. And he gets on the road, and he makes several interesting moves. He radios in, he answers radio calls, and he answers cell phones. Now, ladies and gentlemen, there's a second type of murder that's also been committed here, and that is murder in the perpetration of another crime, or felony murder. And that is count 3 of the indictment. And this requires that the defendant unlawfully killed the alleged Daniel Scott Baker. The state believes that that evidence is fairly clear. That the killing was committed in the perpetration or the attempt to perpetrate the alleged theft, that is, the killing was closely connected to the alleged theft and was not separate, distinct, and independent, and that the defendant intended to commit the alleged theft. And ladies and gentlemen, when you look at the totality here of the situation, the state contends that it does have felony murder as well. Mr. Wiggins was simply not going with law enforcement. He was leaving. He wanted out of there. He had an inoperable vehicle. He saw an opportunity, and he saw several different ways around it. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether the killing
She's got it on the screen and it's reading straight from the case. This is law that you already said. Matter of instruction is sufficient. You can argue it.
I will take it. The killing may proceed consequence by whether follow the theft and still be considered as a crime in the perpetration of the theft.
Now, are you reading from a case or are you reading from?
I was reading from the pattern instruction.
Ladies and gentlemen, if you'll step across the hallway, please.
It's actually fast. Yeah. Consideration touches the factors as time, place, causation, likely,
We're on the record, so.
Your Honor, I'll withdraw these cases.
I'd rather be careful and make sure we're all, for the record, Mr. Evans had voiced an objection to the argument General Sagi was making regarding the law and contended that in his initial objection that she was quoting from law that was not included within my final draft of the jury instructions. I think they have now coincided with each other or had an opportunity to go over it, and I believe now Mr. Evans is agreeing that the language she is using is in fact included in the pattern instructions, and therefore he's withdrawn his objection. Thank you, Mr. Evans, but always err on the side of caution. So, and when, just for the record, when I bring the jury back, I'm going to instruct them once more that argument of counsel, including the closing argument, is not evidence, and that I will instruct them as to the law. The lawyers will be entitled to argue the law and to cite to them what I plan to instruct them about, but that they'll be instructed that argument of counsel is not the law, nor is it evidence. So, all right, thank you. Let's bring the jury back. Thank you, ladies and gentlemen, for your patience and cooperation. Let me explain to you that, again, I have instructed these lawyers to err on the side of caution. So if I interrupt these proceedings to consider something, we're doing it to make sure there's nothing inappropriate taking place. I would indicate to you that after our discussion, then both sides agree there is no reason for any objection to what was taking place. So I would also instruct you to remind you that, as I instructed you at the beginning, and I'll probably instruct you again, that the lawyers' statements, including in their opening statement and in their closing statement, the lawyers' statements are not evidence. They are their opportunity to express to you what their opinions are. And if during their closing argument they make statements referring to the law and what I may charge you, I will give you the instructions. You're going to have your own copy of those instructions. So you'll be the ones who will follow my instructions, but the lawyers are entitled to use those instructions, of which they have a copy, to argue to you and to try to help you understand what they believe the law says on that point. So just keep in mind that this argument is not evidence, nor is it the law. The law will be given to you, and you've heard the evidence during the trial. Thank you.
Thank you, Judge. We'll revisit a little bit. We were talking about killing in the perpetration of another offense, or felony murder. We got to the point where consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged theft. The killing may precede, coincide with, or follow the theft and still be considered as occurring in the perpetration of the theft, so long as there is a connection in time, place, and continuity of action. And that's a lot. And in this case, the killing of Sergeant Daniel Baker also includes the theft of that vehicle. That vehicle is the method that Stephen Wiggins used to get away, used to take the body, used to take the body someplace else, and burn it. This was all occurring at the same time. Stephen Wiggins didn't just shoot Sergeant Daniel Baker and leave him there and run off. He stole Unit 500 to help accomplish his crime at the same time. And after, let's revisit one more thing. At the time that Stephen Wiggins was there shooting Sergeant Daniel Baker, there's no proof here, arguably, that he ever called for assistance for Sergeant Baker. There was no evidence of EMS called to help Sergeant Baker. He took Sergeant Baker from that scene so that no one else could find him. And he even said that in his statement. All I could think is I had to hide him. I had to get rid of everything, the vehicle and the body. So Stephen Wiggins puts Daniel Baker in headfirst into the back seat of Sergeant Baker's patrol vehicle and drives off. And you heard testimony, they drove about 3 miles out to a secluded area. But on the way, we'll submit, he made some very calculated decisions. One of those was to respond to dispatch calls for service to Daniel Baker, because at this time, law enforcement officers were concerned. They were looking for Sergeant Baker. We submit in an effort to throw law enforcement off of his trail. He calls in again as another ruse.
Call 20 on Wednesday, May 30th, 2018, at 6:50 a.m. with a GMT offset of -300 minutes. Agent ID is extension is 115.
Daniel, you good? Point custody. You want me to hang tight here?
It is showing confirmed out of Kingston Springs.
Roger that. In custody, 1 male, on the way to Dixie Central.
Airport.
Dixie Central 306.
Now, ladies and gentlemen, that is proof in this trial. That is an exhibit. You have already heard that. That is Chris Lashley with the Dixon County Sheriff's Office calling into Central asking about Sergeant Daniel Baker. And the voice that you all heard on there was the defendant, Stephen Wiggins, impersonating Sergeant Daniel Baker, the officer in the floorboard or the back seat of his car. And he was acting in a law enforcement capacity, impersonating a law enforcement officer, calling in with those codes, registering those things. Ladies and gentlemen, that is count 6 of the defendant's indictment. And then Chris Lashley, Deputy Lashley, sat here and he told you about calling the defendant on Daniel Baker's issued cell phone and having some sort of exchange with him. And you heard proof from the TBI lab that there was a broken cell phone on the floorboard of that police interceptor when it was found. It was smashed. And the defendant's statement that he took that phone and smashed it. And his DNA is found on that phone. Arguably, he used that phone. He used that phone when he talked to Chris Lashley, pretending to be Sergeant Daniel Baker. That's count 7 of this indictment. Now the defendant travels about 3 miles out into a field, drives through a barbed fence, goes down, very difficult to see, and deposits the vehicle there. He gets out of the vehicle, does something with the hood, does something around the vehicle. And at some point, he takes Sergeant Baker's duty weapon out of his holster, and you are shown that on the hood of the Ford Interceptor underneath. And you heard testimony from the TBI that the defendant's DNA was on that weapon. That defendant had touched Daniel Baker's service weapon and put it there. And then you heard that he admits to taking the backup weapon out of that vehicle as well. And then with Daniel Baker head first in the floorboard, he sets that vehicle on fire. He sets Daniel Baker on fire. And his own words are that he does this because, he watches CSI and other programs like that, and he knew he had to get rid of the evidence. So, ladies and gentlemen, there's a tampering charge. It's count 8. He knew that there was an investigation going on, had a reason to know, and he tried to destroy evidence. He also admitted to trying to disable the GPS locator. Fortunately, law enforcement found the vehicle. He set fire to a vehicle that he had no right to. That's count 9 of the indictment in arson. In count 10, is abuse of a corpse. Because the defendant set Daniel Baker's body on fire after he killed him. And you heard testimony from the medical examiner on this issue. The medical examiner testified that there was no soot in Sergeant Baker's lungs and trachea for this. No indication of high levels of carbon monoxide. So the second and third degree burns on Sergeant Baker's body, the medical examiner's conclusion is after death. And ladies and gentlemen, that is abuse of a corpse. Count one of this indictment we started with was the false report, giving the fake name, the social security number by a legitimate inquiry in law enforcement. He basically lied to the police to tell them who he was, and he had a motive. And Stephen Wiggins didn't stay by that cruiser. He didn't call for medical assistance for Daniel Baker. He fled, and one of the largest manhunts that we've had ensued. And he didn't turn himself in. He was found on the side of the road, and he was brought in. Shots fired, officer down. Those are the last words of Sergeant Daniel Baker. Ladies and gentlemen, it is the state's contention that we have proven every count in this indictment by beyond a reasonable doubt. You have seen, and there are the words of the defendant and the crime on video. We would request that when you go back to deliberate, you find the defendant guilty for the murder of Sergeant Daniel Baker.
For the defense?
Yes, Your Honor.
We told you a few things at the start of this trial. And one of the things we told you is that Stephen Wiggins unlawfully took Sergeant Daniel Baker's life. We told you that. And he did. We told you that you would see the crime unfold on a video. And you did. We told you that that crime was horrific. And it was. We told you that the video of the killing and Mr. Wiggins' statements would make you angry. And they did. It's obvious from your faces. We also told you that we were going to try to conduct ourselves in a way that would show the respect to Sergeant Baker's family and supporters and friends that they deserved. And I hope that we have done that. You know, there's a thing we do in the law in cases where we throw around the term alleged. And you probably heard that term in this case. The alleged victim, the alleged shooter, the alleged crime. And there's good reasons we do that. It doesn't matter why, but let me just be the first to cross that line and say there's no alleged victim here. There's a victim. And that victim is Sergeant Daniel Baker. It's not alleged, he is. There's not an alleged shooter here. There's a shooter, and that shooter is Stephen Wiggins. And we have a courtroom full of victims and survivors of what Stephen Wiggins did. Not alleged, victims and survivors. There's one other thing that we told you in the opening of this case, and that was that we were going to have you consider really just one issue and that's what I'm doing again now. That issue is what you will see in the instructions referred to as reflection and judgment. And we started talking to you about that back in Knoxville, some of you. And we've talked about it in the opening, and that's really all I'm going to talk to you about today, reflection and judgment. Those may sound like simple and benign words, but they're not. The ideas and the concepts behind them are powerful. I mean, they're powerful enough to pull you out of Knox County and put you in the heart of Dixon County. That's why you're here. Premeditation is what separates first-degree murder from second-degree murder. And the state has given you some descriptions of that, and the judge is going to give you the law on that. So I'm not going to go through the law in detail because you're going to have that, and as the court told you, it'll be in writing, and you'll take that back with you after it's been read to you in court today. So what I'm going to ask you to do is when you're thinking about the facts in this case is to consider those two terms as the judge is going to explain them to you and define them for you. And the court will also tell you that you have to consider the mental state of Stephen Wiggins at the time of the shooting. Not months before, not after. You can consider those things, but when we're talking about premeditation, it's really in the moment that you have to consider whether he exercised reflection and judgment. And there's some things about the facts you've heard from witnesses in this case that shed some light on the mental state of Stephen Wiggins at the time. You'll recall that Angela Ezel testified she was on her way to work. She's the one that made the original call. And Miss Ezel said, I was driving to work and I passed this vehicle. And you've seen photographs of the vehicle from overhead, you've seen them from the front, the back, all angles of the vehicle. And it caught her attention immediately because it was parked in the wrong lane, stopped in the middle of an intersection. And as she drove by, the occupants, she said, were either asleep or passed out. Passed out in the middle of an intersection in the wrong lane. Multiple photographs verify that. So you have to consider what kind of judgment is going on by the occupants of that vehicle when they're leaving a car in the middle of the road in the wrong lane. That's where we start when you're considering the mental state at the time. And then we have the video. And we told you about the video. And I suspect, as I said, it was as horrific as we warned you it was going to be. That's why we asked questions of you early on about can you view such things. 6 minutes go by, and if you believe that that door was operable, Stephen Wiggins then could have opened it at any time and shot Sergeant Baker, but he didn't. For 6 minutes. He could have rolled down his window and fired from his side of the car, and he didn't for 6 minutes. And I submit that shows he wasn't planning to because he didn't. If he was sitting there with that intention, he could have done it at any time. And the video doesn't show who's firing those first shots, but we know they came from the passenger side where Castro Miles was sitting. It came from her side of the car. And we know that she ran away, and she hides, and she's arrested later. And we know that in those few seconds, when Sergeant Baker walks around the car, he had told Mr. Wiggins to keep his hands where he could see them. And you saw from his interrogation video that it's Agent Neese asked him repeatedly, well, when did you get the gun? And he can't give a clear answer of that. And you can rest assured that if he had had a gun in his hand before Sergeant Baker walks around the car, he would have walked around the car. So now we're talking about 6 minutes he does nothing, and now we're down to a few seconds of when this plan was supposedly hatched. And you hear talking inside the car in the video. So is he planning or is he talking? And what are they talking about? And who's saying what? So now we've got talking going on in a matter of a couple of seconds when Sergeant Baker walks around the car. And you have to wonder, did he even have time to think at that point? Because that's the question, remember? Reflection and judgment. That's the issue here. And we told you that Mr. Wiggins was going to say things in his statement that wasn't true. And you've heard that statement. But we also heard from the ER doctor that Mr. Wiggins wasn't 100% when he discharged him. That's not what ER doctors do. We get them stable and we move them. And you know from the ER records that are in evidence, and you can review those, that many of Mr. Wiggins' levels were off. He apparently had some sort of what appeared to be a seizure. It's in the records. He's given Keppra to control that. And we know that there's psychiatric history based on those. And that's the condition with which he goes in and makes that statement. But there's one part of that statement that I think stands out. Agent Neese asks him, okay, he's walking around the car, and that means you had what on him? And if you go back and you look at that portion of that interview, look at the confusion in Mr. Wiggins. He's what are you talking about? Well, I had what? I had something on him? What did I have on him? Of course, we know from hindsight, looking back, that what Agent Neese is getting at is you had the element of surprise. But if you look at that portion of the video, I submit to you, you will see Mr. Wiggins, even at that point, is like, I don't know what you're talking about, because he wasn't thinking about that at that point. Reflection and judgment. That's what we're here about. Now, the state's made some comments, and they get to come back after I do because it's their burden, and so they always get to go last. But they've made some comments initially. It makes you want to think that maybe Mr. Wiggins' actions after the shooting, okay, maybe those actions give some evidence to how his mind was working. And he was reflecting and judging just fine. But I submit to you, if you look at those actions, there's a difference between reactive and reflective. There's a difference. He may have been reacting to something that just happened, but that doesn't mean he was, even in that moment, really reflecting and using much judgment. Because he got a total of 3 miles away before he abandons the car. If he's got this master plan that he's going to steal a car, why doesn't he just steal it and keep driving? He doesn't. He reacted, and then he stops, and he gets out of the car. And so just briefly, the issue of felony murder, there's no evidence that those are closely connected. He wasn't stealing a car, and in the process of stealing the car, killed Sergeant Baker. That's not the chain of events that you saw. And here's the biggest fact that you need to consider about reflection and judgment. And when I use reflection and judgment, you are the perfect example of reflection and judgment. You all are sitting here slowly and methodically hearing pieces of information. You're having time to process those. You're listening to arguments of lawyers. You're going to listen to instructions on law from the court. And then you're going to have time to go back and deliberate. That is reflection and judgment. That is time to consider, time to think, time to make important decisions. And you're using this process of reflection and judgment to reach a verdict. But here's the biggest thing to show you what was in Mr. Wiggins' mind is when he had time to reflect and use judgment, when he was sitting out there for 2 days, he had 2 functioning firearms, 2 pistols that you've heard expert testimony say were in perfect working order. They were loaded, the magazines were full and one in the chamber, and he had a bag full of ammunition. He's in a concealed position when a state trooper drives by, and he does nothing. He surrenders, and he says, "I'm Stephen Wiggins," and puts his hands over his head. Contrast that ability to reflect and use judgment when he has time and he's not stressed and there's not things going on with the very few seconds that we're actually talking about in this case before he fires that handgun. And that fact also, in addition to many others, are the reason why you should completely disregard Brian Hudnall. That man couldn't even tell the truth about what he had been convicted of when I've got the paper right under his nose. That chain of events, I popped in my head and I immediately contacted law enforcement. Well, if immediately in his mind is 6 months, he needs to work for Congress, because it wasn't immediate. He took his sweet time. You know what he waited for? He waited till he got indicted in August of 2018 and saw what kind of time and charges he was facing. Then has conversations with his lawyer and goes to court. Then he decides to reach out to law enforcement 6 months later with this supposed information that he has. That alone shows you that that probably never happened. That statement was never made about smoking a police officer. But we also know that when Mr. Wiggins had the 2 guns and he's sitting on the side of the road 2 days later when he's able to reflect and use judgment, that he didn't do that. That's contrary to that. Second-degree murder is the knowing killing of another. And that's when someone's aware their conduct is reasonably certain to cause death. That's second-degree murder. You're conscious that your conduct could cause that result, and it does. That's the distinction. Premeditation requires that the person's mind is clear, free from passion and excitement, and that they could, again, reflect and use judgment. That's the difference. We're not asking you to not hold Mr. Wiggins responsible for the killing. That's not what I'm standing here doing. And that's what we told you at the beginning of this trial. We were not here to say he didn't kill him and that Sergeant Baker is not a victim. We're asking you to consider the law. And the law requires that as angry as you may be, as biased as you may now be, that you not allow those emotions in, and you'll get instructions on that. Your decision has to be done with reflection and judgment. You have to also have those emotions put to the side so that you do what's right, not what's just vengeful, whether you feel the person deserves it or not. That's your civic duty. That's what justice is. So that's what we're asking you to do, is to consider in this case. You think in those few seconds, Mr. Wiggins, in that condition, on that side of the road, in a car parked in the wrong lane, was using reflection and judgment. We told some of you during the jury selection process, we went over about your verdicts and how you would expect in the jury room that your opinions and feelings and judgments would be respected. And you all indicated that, yes, you would expect that your personal feelings and your decisions would be respected. Well, that's not just true between yourselves. That's true for us as well. Whatever your decision is, we respect that. And we also thank you for your time and your attention to these facts, and for you taking the time to reflect and use your judgment in this case.
Counsel, approach the bench, please. Well, it's not on the record. The jury's. All right. State may have the final say.
thank you for your time and attention. This is a extremely difficult case for anyone to process. You've been faithful watching the evidence, long days, lots of witnesses. It's a lot to take in in a 3-day period. I started off my opening statement. Shots fired, officer down. I said that because as the proof shows, that was a warning to all oncoming law enforcement, EMTs, civilians, to be mindful of the defendant. Why did Sergeant Baker need to give that warning? Because the defendant was able to fool Sergeant Baker once. How did he manipulate and fool Sergeant Baker? By using his reflection and judgment. He was able to convince Sergeant Baker to stop the felony encounter, to reholster his weapon, and allow the defendant to exit that vehicle through the passenger side. That takes an exercise of reflection and judgment. But before we go into more specifics of his reflection and judgment, let's talk just briefly about why shots were fired in the first place, the motive of the defendant. Mr. Etheridge, if you would bring up slide 1.
Jason Young went to my house on Yellow Creek Road looking for me. That's why I'm leaving. My everything was packed up and was leaving the state. I was gonna run out of the state.
Where were you gonna go?
And he really decided to. Kentucky, Illinois, New Mexico, California, somewhere.
Ladies and gentlemen, the defendant was on the run. His intent had already been made up. His exact design occurred on May the 30th, how he killed, murdered, executed Sergeant Baker. But this is a man who acknowledges in his interview that he was on the run. And you know that from further evidence in this case. The day before, he was on the run from Kingston Springs. Why? Because he stole a car. He acknowledges in his own interview that he had 2 active warrants. He's on the run. He's going to leave the state. And now he finds himself in an inoperable car at the intersection of Tidwell Switch and Sam Vineyard. He's on the run. He has active warrants. He's attempting to elude law enforcement. He will not be arrested. And that's why the statement of Brian Hudney is important and makes sense. Because if law enforcement attempts to arrest the defendant, he will smoke their ass. That's what he did. That's exactly what he did. My name is Ray Crouch. Here's my driver's license. On May the 30th, the defendant had his identification just like I do. There it is. was in his wallet. But when asked for proof of identification by Sergeant Baker, the defendant made the decision to do what? And this is what shows you his deliberation process, his thinking, his judgment. He made the decision to give a false name. In his interview, he said he provided the name Scott Wiggins. He provided a real social security number to Sergeant Baker belonging to someone else. That takes calmness. That takes reflection and judgment to think about providing a social security number and fake name. Use your common sense. Most every person in the world, if they get pulled over for speeding or any other law enforcement officer, is a little bit nervous just because you're not used to getting pulled over. But Mr. Wiggins, the defendant, is sharp enough and clear enough thinking that he gives a fake social security number and a fake name. Why? Because he's not going to be arrested. He's trying to get out of the state. He's eluding law enforcement. That's his motive. Think about the acting job of the defendant. My door won't open. This door won't open. I have to use pliers. Common sense. This is a design reflection and judgment are shown. He is sitting there in a 6-minute encounter, as the defense has pointed out, acting the entire time. Acting. Fake name, fake social security number, faking that the door is broken. Why? Why would he need to do all that? To elude law enforcement? Because he's going to smoke their ass, and he did. And when did he do it? After Sergeant Baker reholstered, walked around the vehicle, which you can see. Windows, you can't see through them because of the humidity. And as soon as Sergeant Baker is in eyesight, bam! That's reflection and judgment. That is reflection and judgment. Targeting someone, pretending that you are someone else to deceive law enforcement. He said in his interview that he had kicked that loaded pistol up underneath the seat. He concealed that weapon and didn't get it out until Sergeant Baker couldn't see what he was doing. These are all actions that take reflection and judgment, ladies and gentlemen. That pistol didn't just end up in his hand. That trigger doesn't squeeze itself. 10 shots fired. Now look, that video is horrible to watch. And we've seen it way too many times. And I'm not asking you to see it again. But if you want to, it's available for your viewing, as is all the evidence. 10 shots fired, count. 6 into Sergeant Baker. 3 in the head. 3 of those come after the defendant gets out of his vehicle, goes back to Sergeant Baker, does not render first aid, does not perform chest compressions, executes him. Executes him. The defendant gave a great acting job at that door. And then even in his statement, oh, there's 2 rods, one to the unlock button and the other to whatever. No, there's no rods. There's no pliers needed. That door opened and closed fine. It was an acting job. Because he was going to smoke his ass, and he did. Any law enforcement officer that would have encountered him that day would have been smoked just like Sergeant Baker. That's an execution. There were no chest compressions. That's an acting job. He was trying to play up again to Agent Neese in that interview. No tears. No tears from Agent Wiggins. Those are self-serving statements. Oh, I did 8 to 10 chest compressions. No. He walked up, and according to the medical examiner, 2.5 to 3 feet. Bam! Bam! That is an execution. The intent to kill must have been formed prior to the act itself. That is premeditation. That's what the instruction will say. The intent to kill must have been formed prior to the act itself. Giving a fake name, social security number, going under your seat to get a weapon, waiting for someone to get into target sight line. All of those are an intent to kill. I'm going to smoke his ass. And he did. He's charged with theft of Sergeant Baker's Glock 357.
Silence is probably not a good thing.
I don't know what to say.
Was that not what you wanted?
I don't know.
Sergeant Baker was surprised on Christmas morning with a present, a 357, from his wife. She testified that she put it in a large box.
That's not what you wanted?
She testified that she put it in a large box
It's not the one you wanted.
to surprise him, and so to be fooled as to what was inside the box. You would all agree that was intentional of her to wrap it in that larger box to disguise the small box. Just as it was intentional and premeditated for the defendant to hide his weapon and wait until Sergeant Baker was in sight for a clear shot. There's no difference. Intentional, he decided to kill him. You do not point a loaded weapon at a police officer, a felony stop, unless you intend to kill him, and he fired 10 times. Calmness after the killing. That ought to reflect to you how he already had the intent and motivation to kill. He was able to quickly get back, remove the keys, load Sergeant Baker's body into that vehicle, and get out of the area quickly. Just as quickly as he provided a fake name and fake social security number, he quickly loaded that body up and was gone, and was able to not only figure out how to use the radio, but to key up and respond. That is calmness, ladies and gentlemen. That is coolness. Who else could do that? You just put 6 rounds into a police officer, 3 in the head, and you're able to key up and pretend that you're a police officer? This is coolness and reflection and judgment to the nth degree. Answer a cell phone. This guy is multitasking after having loaded a dead body into the back of a car. He's using a radio and a cell phone. Now that ought to show you how well he's thinking, how quick he's thinking, how collected he is. Who else could do that? Who else could, in that matter of minutes, attempt to disassemble the GPS locating device on a vehicle? Get underneath the hood of the vehicle. Take the fuse panel off. find incendiary items and light them on fire, and elude police for 2.5 days. And I do respect the defense attorneys being respectful, but I disagree with Mr. Hopkins on multiple issues. Mr. Wiggins did not peacefully surrender himself. Remember his interview? He said he woke up to THP. That's what he actually said, that he was dizzy, passed out, and woke up to THP standing over him. This wasn't a guy who turned himself in. This was one of the largest manhunts in the state of Tennessee's history. And he was intentionally eluding police. An acting job. An acting job. Acting in and of itself takes premeditation. To pretend to be something you're not, how much more premeditation can one have than to pretend to be someone else? That takes reflection and judgment alone, to pretend to be someone else. I asked you early on in jury selection in Knoxville. Really, I didn't ask much at all. I didn't do a whole lot of talking. But I did ask every one of you, follow the law of the state of Tennessee. Follow the judge's instruction. And you all agreed. And one of those instructions you're going to see on premeditation is it's not necessary for the purpose to kill to pre-exist in the mind of the accused for any definite period of time. It's not. His purpose pre-existed for a long time. The entire time he's been evading and eluding. His purpose was already determined. His motive already determined. He was not going to be arrested. I'm almost finished. I agreed to keep it short. You saw the video of Sergeant Baker opening his Christmas present. And I want to leave you, that's the image of Sergeant Baker I want you to have in your heads. Sergeant Baker on May the 30th represented law enforcement. He represented the Dixon County Sheriff's Office. He represented the citizens of Dixon County. He checked in response to a dispatch call for service. He represented what has been known as a thin blue line. On that day, as can be reflected in this photograph, that thin blue line was burned by the defendant. By the defendant, who shot him in the head 3 times and set him on fire. By the defendant who said this:
As I realized there wasn't no saving him, I backed up. I think I was on his side. And I just wanted to close my eyes and pull the trigger. I think it might have been twice. Just
Why'd you do that?
I don't know. I guess from that point on, I realized how bad it was. You know, it's like a dog. You don't let it suffer. You make sure, you know.
Reflection and judgment. He acknowledges that. I realize. Think about that word, realize. That's reflection and judgment. Acknowledging. Think about what the defendant, in his own words, is saying. Put him down like a dog? Like he's taking an animal to be euthanized? What more reflection and judgment can be demonstrated? That alone is a separate event of premeditation. That alone is premeditated murder. I realized, and I put him down like a dog. Like a dog. Today, you represent a thin line. You're a thin line that are the sole fact finders in this case. You're a thin line of justice. You. The thin blue line was burned on that day. The thin line of justice does not need to be burned by the acting of the defendant. Don't be fooled. Do not be fooled. Convict this man of premeditated murder, felony murder, every other.
All right, ladies and gentlemen, at this point, I have a 30-some-odd page charge to read to you. But before we do that, your lunch is here, so we're going to give you an opportunity to break for lunch, and then we'll come back in after lunch and conclude with my instructions, and then you'll be allowed to deliver it. I would remind you that after I've read all of the instructions to you, we will be selecting 4 of you to serve as alternates. And I'll explain further about that once we've reached that point. But in this situation, I would remind you that even though you've heard all of the proof in the closing arguments, you have not received my final instructions. So my previous instructions that I've repeated often are, don't discuss this case among yourselves, don't begin your deliberations, go in and have a good lunch, and then when you come back, I'll give you the final set of instructions, choose the alternates, and then you'll be allowed to begin your deliberations. Thank you. We'll retire to begin your lunch. So that everyone's clear, after I've given my final set of instructions, we will choose the 4 alternates. Those 4 alternates will be separated from the other 12, but they will not be released to return home. They're going to be kept with us, and they will be held separately apart. They will be fed separately, transported separately, and so forth. If it gets to a sentencing phase that the jury will be setting the punishment on, then they will have 4 chairs set in front of the jury box. They will be separated. They will be instructed they cannot communicate with the other 12, and they would only be available in the event at a sentencing hearing that there was a need for a replacement juror, but they will be housed and fed in the courtroom 6 down here, which will be locked to the public from the outside, and they'll be kept separate and apart in that fashion. So wanted to make everyone aware of the process for keeping those separate until we determine whether or not we need them. So at that point, it is now 12:25. Let's be at lunch until 1:30, and then we'll resume. So.